Now, the freaking internet is calling OTF Dede a snitch. I'm going to just make a long story short. He's not a snitch, and I'm going to prove it. Spoilers ahead. You're going to be very upset with what I decide to say. Harbaugh, we know how to say that name because of Jim and John Harbaugh. Well, me personally. United States of America versus Durk Banks. Defendant Wilson's motion to sever. Hearing date November 18, 2025. To the Honorable Court, all parties in their counsel of record. Defendant Deandre Wilson, by and through his counsel of record, Craig A. Harbaugh, hereby moves this court for an order severing his trial from that of co-defendant Durk Banks and any other co-defendants whose trials are joined with Mr. Banks. Now, y'all are saying he's snitching by saying Lil Durk's name all throughout here. And I'm going to show y'all why you guys actually got this one wrong, but I overstand exactly what the hell y'all talking about. This motion is made pursuant to Federal Rule of Criminal Procedure 14 on the ground that a joint trial will cause compelling and incurable prejudice to Mr. Wilson as a result of prejudicial spillover from extensive other acts evidence noticed by the government that overwhelmingly concerns Mr. Banks and other alleged actors and would not be admissible against Mr. Wilson if he were tried alone. Meaning y'all gonna add all this stuff about Lil Durk and have me sitting over here right next to him. But if y'all pay attention, the key thing that he said right here, and I need y'all to really, really take this one home, right? It literally says that a joint trial will cause compelling and incurable prejudice to Mr. Williams as a result of judicial spillover from extensive acts evidence noticed by the government that overwhelmingly concerns who? So he's saying that, hey, bro, the feds, y'all really want Lil Durk. I ain't got nothing to do with none of that. The motion is based on this notice, the attached memorandum of points and authorities, the government's initial Rule 404B, notice date September 1st, 2025, all files and records in this case, and authorities cited herein, and any further evidence and argument the court may permit. Respectfully submitted, dated October 6th, Craig Harbaugh. And we just gonna skip all of this crap right here. These are who they are using and blah, blah, blah. Memorandum of points and authorities, introduction. At the outset, Deandre Wilson does not concede that the government's notice is adequate under Rule 404B, that the alleged acts are supported by competent evidence, survive a Rule 403 analysis, or that they are admissible against anyone in this case. Mr. Wilson will join defendant Durk Banks' motion in limine to exclude government's proposed FRE 404B evidence filed in contemporaneously and fully expects the court to exclude the extraneous, no, not how to say that. I never knew how to say that word right. Extraneous, highly inflammatory evidence. But if the court were to allow the government to introduce this evidence, severance is the only way to protect Mr. Wilson's right to a fair trial. The government's notice sets forth extensive other acts evidence by almost entirely directed at co-defendant Durk Banks. Allegations of violent retaliation, murder plots, paid bounties, and directives to hunt rivals spanning multiple jurisdictions and years. By contrast, Mr. Wilson appears, if at all, only peripherally included in two text threads reflecting general chatter around Mr. Banks' alleged feud and threats in terms of both of severity and breadth. These allegations dwarf the current charges against Mr. Wilson. Mr. Wilson will be forced to devote extensive time and resources to defend against evidence that has almost nothing to do with him. A curative instruction will not suffice. Given the extensive inflammatory evidence, there is a grave risk that the jury will determine Mr. Wilson's guilt, not based upon the evidence, but based upon alleged violent acts of someone else. There is no way to ameliorate the prejudice to Mr. Wilson. Severance is required. He's basically saying this. Hey, bruh, y'all putting me next to Durk when that's exactly who y'all want. I'm only in here on a couple of sentences, on a couple of text threads. So, bruh, let me go by myself. And anybody who's calling OTF Dede a snitch, what he's basically saying is the evidence right here that we're about to read, because it's been popping up everywhere, is stuff that the government is saying that he did. He's not saying that it happened. And on top of that, Lil Durk is trying to sever himself from the case as well. So are y'all going to call Lil Durk a snitch too? Yeah, I didn't think so. So let's continue on, man. If you understand what I just said right there, hit that like button, let us know something, force this back into the algorithms. Man, we back doing our thing. Let's roll it. Background. On September 1st, 2025, the government severed its initial Rule 404B notice, or sir, my bad. I said severed, my fault. Anyway, served its initial Rule 404B notice identifying a series of alleged prior acts it intends to introduce as evidence as motive, intent, preparation, and plan by co-defendant Durk Banks. See Declaration of Craig A. Harbaugh, Exhibit A. The notice overwhelmingly targets Mr. Banks, and nearly all of the government-listed acts consist of alleged violent conduct, threats, or admissions by Mr. Banks. Deandre Wilson is not identified in the bulk of these allegations, and where his name does appear, it is solely in connection with group text threads initiated and driven by Mr. Banks. Evidence related to Banks' rivalry with Taquan Bowman. The first describes evidence of Mr. Banks' alleged efforts to exact revenge against Taquan Bowman, aka Quando Rondo, following the 2020 killing of Devon Bennett, aka King Von. According to the government, it intends to introduce surveillance footage and witness testimony related to the murder of Bennett in Atlanta on Georgia, November 6, 2020. Surveillance footage and witness testimony related to the attempted murder of Bowman in Blackshear, Georgia, on or about May 2nd, 2021. Mr. Banks' lyrics and statements, such in his line, "Who won't smoke? They be on my page like stop for ball. I know they trolling me." And his podcast interview remarked, "For some reason, I just don't see the comments no more. We're here though. We different in Iraq." And social media comments directed at Mr. Banks urging him to slide for Vaughn. None of these allegations identify Mr. Wilson. The evidence relates exclusively to Mr. Banks' feud with Bowman and the public pressure on Mr. Banks not to Mr. Wilson. Evidence related to Banks directing and ordering violence. The second category consists of a wide-ranging set of allegations claiming that Mr. Banks placed bounties on otherwise directed violence. Again, Mr. Banks is central to the government's allegation. Mr. Wilson's name surfaces in only 2 text chains, and in each instance, he is a participant, but not the originator of any statement. Stefan Mack Bounty. On January 27, 2022, the notice states the government will introduce text messages, surveillance footage, and forensic evidence linking Mr. Banks to an alleged bounty for the killing of Mack. Mr. Wilson is not identified in connection with this incident. On April 2023, text chain Munna Duke feud. Hold on. Now, I ain't gonna hold you. They ain't snitching on Durk, but they damn sure is running him over, backing the bus up, running him over, backing the bus up, running him over. I'm not saying OTF Dede is a snitch, because that's not what's been proven here, but this 100% is definitely grounds for, shit, I'll tell. This definitely got grounds for, tap me in the game, coach. This sound like Buddy is willing to tell. How true that is, I don't know, but nigga, this give me all type of Snake vibes, bro. I don't know if I would have felt comfortable with my lawyer including all of this shit, bro, because you ultimately had to sign off. Damn, my Yankees is losing. Damn. So, yeah, bro, this right here, I ain't gonna hold you. This nigga definitely is throwing Lil Durk all up under the bus, bro. But at the same time, he's only using what the government is already saying. What he's doing is saying, I ain't involved in none of this. Y'all said Durk did this, Durk did that, Durk did this, Durk did that, Durk did this, and this, and this, and this. First off, the shit that y'all even accusing me of, I didn't even originate, nor did I do any of this stuff, bruh. They added me into them damn text messages. I did not do this. So come at me on my own stuff, on the stuff y'all saying I did. Don't tie me to Lil Durk, because the stuff y'all saying that he did, it looked like his ass getting ready to go down for a life sentence. Let's continue on. April 2023, text chain Munna Duke feud. The notice claims a group text between defendant Banks and OTF members, including defendant Deandre Wilson, Antonio Jones, aka Booney Mo, and PW1, reflected Mr. Banks' frustration that O-Block was not properly retaliating for Bennett's death. In the thread, Mr. Banks, not Wilson, declared, "I'm finna pipe it up." Booney Mo responded with, "Blood is green," emoji of car and green light, getting shit together now, no phones. The government expects PW1 to testify about purported follow-up plans involving others. Significantly, the government attributes no statement to Mr. Wilson in this exchange. His presence is merely noted as being on the text chain. There is no claim that Mr. Wilson agreed with, endorsed, or acted on Mr. Banks' statements. In April 2023, Instagram chain, another text chain between defendant Banks, defendant Wilson, Booney Mo, and Devonshea Collier allegedly shows Mr. Banks. That's crazy, bro. They put... Nah, bro, not my mans. They ain't put my evil twin in there. Mr. Banks forwarded an Instagram message. He said to rival Richard Ramsey stated, "I got them hunting you up. Ads better have 3 ski masks on." Mr. Wilson is not alleged to be the author of the threatening statement. His name appears only as a participant listed on the chain. The notice does not claim that Mr. Wilson commented on, endorsed, or even responded to Mr. Banks' message. April 2023, Booney Mo audio. A voice note allegedly conveying Mr. Banks' instructions regarding money and sliders, getaway cars. Mr. Wilson is not identified, and there is no evidence he received the audio message. Lyrics. The notice cites multiple lyrics by Mr. Banks, including aha, smirk, slide, slide, slide. Don't respond to shit with Vine. They dropping locations. I'm getting it done. Rumors. I don't want no niggas who catch. I want the one I pay for. And scoom his ass. Bounty Hunter, he ready to crack that little bitch down and get off her. Bounty Hunter, he ready to crack that little bitch down and get her off. These statements are attributed solely to Mr. Banks. That's not even a song, bro. It's supposedly a link, but whatever. I mean, a leak. While the government labels these acts as relevant to show a laundry list of reasons under 404B related to Mr. Banks, it fails to identify statements or conduct by Mr. Wilson that would make the evidence admissible against him. Legal standard. What he's saying is this. I'm in all these freaking chains, in these text threads, these Instagram threads, all of this crap, but bruh, let's be fair, square, obvious and honest. Bruh, I ain't say nothing. But then again, what they can always come back and say, and I think they will, is, hey, homie, you knew about it? That's conspiracy. Knowing about something that's about to happen makes you a co-conspirator, whether you say anything or not, because you knew a crime was going to happen. Now, his lawyer definitely will argue the vagueness of it all, but you kind of can't because you're acknowledging that Lil Durk wanted to do certain things. And this is how you cats always get caught up. It's shit like this. Because if I'm a prosecutor, I'm going to say, well, damn, you just damn sure made sure you knew that this crap was about to go on. And I guarantee you that's exactly what the feds are going to do. They're going to say his ass knew about the crimes. So if he didn't want to be in any of this crap, he should have either excluded himself about them text messages, or he should have said, hey, bro, get me up out of here or something like that. But because you knew there was a crime and you're factually acknowledging these were crimes that are about to happen, sit your ass with the rest of your homeboys. And I think that's why they will not grant a severance based off of the stuff that they just did there. Your damn lawyer need to get his ass fired. Legal standard. Federal Rule of Criminal Procedure 8B provides that an indictment or information may charge two or more defendants if they are alleged to have participated in the same act or transaction, or in the same series of acts or transaction constituting an offense or offenses, even when a joinder of defendants in one indictment is permitted under Rule 8B. However, if the joinder of offenses and defendants appears to prejudice the defendant or the government, the court may order separate trials of counts, sever the defendant's trials, or provide any other relief that justice requires. Yeah, they talking about the Supreme Court stuff. Nobody gives a damn about any of that. Difficult for the individual, whatever the hell. Evidence admissible solely against co-defendant under rules 401, 404B. That will be excluded under rule 403. We're going to just get past this part. In determining whether joinder is prejudicial, a court must consider whether the jurors have the capacity to compartmentalize the evidence and follow the trial court's instructions and appraise the guilt or innocence of each defendant based solely upon the defendant's own acts, statements, and conduct, and the independent evidence against the defendant. Yeah, let's keep on going. Argument. Here we go right here. Mr. Wilson disputes the adequacy and admissibility of government's Rule 404B as the initial matter. Mr. Wilson disputes the adequacy and admissibility of the prosecution's Rule 404B notice in its entirety. He does not agree that the notice satisfies Rule 404B. B's procedural requirements that the government has sufficient proof to establish the acts described or that the alleged conduct is properly attributable to Mr. Banks. So, all right, that kind of saved him right there. So basically, they're saying that y'all ain't even prove that Durk did this shit. Okay. Yeah. All right, cool. Or to any co-defendant. Mr. Wilson, likewise, does not concede that these allegations are admissible under Rules 404B or 403 in any trial. To be clear, Mr. Wilson preserves his objections to the sufficiency and admissibility of this notice and joins the separate motion seeking to exclude this evidence in full. Basically, whatever the hell they say, they want excluded. I want it excluded too. Nevertheless, if any portion of the voluminous notice material were admitted against Mr. Banks, it would be patently unfair. Mr. Wilson will be forced to defend himself before a jury saturated with evidence that, by government's own account, has nothing to do with him. The sheer disparity between the evidence against Mr. Banks and the absence of comparable evidence against Mr. Wilson compels severance in order to protect his right to a fair trial. The government's 404B case against Mr. Banks will create severe and incurable spillover prejudice against Mr. Wilson. If Mr. Wilson were tried alone, virtually all of this evidence would be inadmissible as improper propensity evidence. But in a joint trial, the jury would be exposed to the avalanche of inflammatory material, accounts of shootings, claims of bounties, and Banks' confessions and lyrics. So they're not saying he actually said anything really right now. They're saying his own songs got him. Against that evidentiary backdrop, Mr. Wilson's mere inclusion in group text would easily be blurred into guilt by association. This is precisely the danger the courts warn against when they caution that jurors might impute the guilt of some defendants to other defendants, United States versus De Rosa, even if relevance could somehow be strained. The 403 dictates exclusion. Courts have recognized that when voluminous 404B evidence against one co-defendant dwarfs the case against another, severance is necessary. Here, the disparity in the evidentiary weight is dramatic. While Mr. Banks will face a case centered on violent conspiracies unfolding over 3 years, the government's allegations concerning Mr. Wilson amount to being copied on a text thread in a joint trial. The risk is that jurors will conflate and collapse both narratives, which undermines the basic right to individualized guilt determinations. It is to ask too much of lay and perhaps judicial minds to expect jurors to filter through incendiary narratives of revenge killings, threats, and lyrics while keeping Mr. Wilson's isolated reference separate. The introduction of irrelevant inflammatory evidence against Mr. Wilson will significantly undermine his strong defense. For the sake of argument, the government's allegations, the case against Mr. Wilson is not strong, forcing Mr. Wilson to confront extraneous 404B evidence would allow the government to secure a conviction without satisfying its high burden of proof. According to the operative indictment, Mr. Wilson, A, was not a leader of OTF, B, did not initiate a bounty or make any payments, C, did not procure any weapons, vehicles, or any other items associated with the offense, D, did not drive any vehicle, and E, did not use or possess any firearm. Although the government accuses Mr. Wilson of the acts such as purportedly recruiting individuals, this information comes from a cooperating witness. Whoa, such testimony is inherently suspect and must be evaluated with greater caution than that of other witnesses. Ninth Circuit Model Criminal Jury Instruction 3-9, allowing the government to introduce overwhelming extraneous evidence against Mr. Wilson runs the risk of unfair tipping the balance in the prosecutor's favor. So he just said, hey, bruh, first off, all this shit y'all saying that I did, y'all don't even have no proof. Your only proof is a witness, which means the government, if true, let me save that right there. Let me put that out. If true, bruh, they're going to say, oh yeah, we got this. We got that. But it ain't true. It's only somebody saying, hey, bruh, yeah, I was there. And remember, I think it was only 5 people that got arrested, but 7 in total. Yeah, something is fuddy-duddy right here. I ain't gonna hold you. Y'all might not like what OTF Dede has done, but he definitely exposed a whole lot of shit that the government basically was not trying to let out. This basically exposes the whole plot of everything. Y'all may not like it, but bruh, this was a genius move. Hate on the man all you want, say whatever you want. They not gonna kick his ass off of there. But basically, what they're letting it be known is A, B, C, D, E, F, G. The words that y'all using, the people y'all using, all of these damn things that y'all doing is based off a conspiracy. It's not actually based off of real evidence. This is witnesses and text messages. And granted, that's normally enough in anything. But what the hell do the witnesses have to gain from this? Because if there's a witness who's already on trial for murder, we already seen it with the Cornelia Smith shit, bro. I will tell you any story that y'all want to hear. Man, let's bring it home. I had to turn that fan on, so if y'all hear it, y'all hear it. Limiting instructions cannot cure the prejudice. The government may argue that limiting instructions can cure any prejudice, but case law and common sense reject the claim where inflammatory spillover evidence dominates the trial. Zerfiro, I don't know, acknowledged that severance is warranted where such prejudice is great. The Ninth Circuit has similarly recognized that no instruction can erase the mental imprint left by devastating allegations, murders, bounties, and threats that have nothing to do with Mr. Wilson. Here, exposing the jury to repeated references to revenge killings, social media pressure campaigns, and violent lyrics by Mr. Banks, then instructing them to disregard all of it when considering Mr. Wilson is a fiction. It is unreasonable to ask jurors to engage in these mental gymnastics. Gallo, to tell the jury to ignore this proof is to ask the impossible. The prejudice cannot be instructed away. Severance is the only adequate remedy. Against this backdrop, severance is the only way to safeguard Mr. Wilson's trial rights. Redactions, limited instructions, or partial exclusions will leave in place the central problem that the government intends to present an overarching narrative of violence and retaliation that does not involve Mr. Wilson, but that inevitably colors the jury's perception of him. Severance will not only protect Wilson, but also streamline the evidence at his trial to matters actually relevant to him, rather than embroiling him in proof aimed at another defendant. Conclusion: for these reasons, the court should sever Mr. Wilson's trial from Mr. Banks and other co-defendants against whom the government intends to introduce Rule 404B material. Respectfully submitted, Craig A. Harbaugh. And then y'all can see this is the declaration and all of this crap, and he declares in the perjury, blah, 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 blah. But here's where shit gets ill, right? And this is what people were reading, right? And I had to read this. Like, I know it's already a long video. I appreciate you guys hitting that like button. If you haven't right now, make sure you hit that like button so you can get this damn PS5 away from me and this damn Xbox away from me, bruh. We already at 39K subs, so we're almost there. Anyways, their counsel has discussed during parties meet and confer August 13, 2025. We're writing to provide you with preliminary notice pursuant to Rule 404B and federal rules of evidence regarding certain acts that the government intends to prove a trial in the above referenced matter. The government views the evidence described in Section 1 as direct evidence and inextricably intertwined with the changes in the second superseding indictment and therefore not subject to notice pursuant to Rule 404B. However, out of an abundance of caution, the government gives notice pursuant to this letter for the evidence described in Section 1. With this letter, the government again requests all reciprocal discovery to which it is entitled under Rules 16B and 26.2 of the Federal Rules of Criminal Procedure, evidence related to Durk Banks' rivalry with Taquan Bowman. The government intends to introduce evidence relating to defendant Durk Banks' motive, intent, preparation, and plan in one, seeking revenge of Taquan Bowman, aka Quando Rondo, for Bowman's involvement in the death of Davon Bennett, aka King Von, on or about November 6, 2022. Place the bounty for Bowman's death and conspiring to kill Bowman in retaliation for Bennett's murder. And 3, directing his co-conspirators to track, stalk, and kill Bowman in Blackshear, Georgia on or about May 2nd, 2021, and in Los Angeles, California on August 18th through 19th, 2022. The evidence includes, but is not limited to, surveillance footage and witness testimony related to the murder of Bennett in Atlanta, Georgia on November 6th, 2020, including the fight between Bennett and Bowman prior to Bennett's murder. The government reserves the right to seek appropriate remedies for defendant's failure to comply with defendant's reciprocal discovery obligations, including by seeking to exclude the use of undisclosed discovery as evidence at trial or other evidentiary proceedings where a defendant may withhold discovery by inappropriately claiming it is impeachment material, excluding undisclosed checks at trial. The defense made a strategic decision to withhold evidence until the government would be unable to fully investigate, made a strategic decision to withhold the document until after the close of the government's case. He and his client must accept the risks arising from this behavior. Surveillance footage and witness testimony related to the attempted murder of Bowman in Blackshear, Georgia, which means they got snitches that came out or was shooters in that instance. Defendant Banks' admissions to showing the pressure he faced from fans to slide for Von, exact revenge on Bennett's death, including but not limited to defendant's lyrics from the song Who Wants Smoke. And we already said all that. Defendant statements in a podcast of DJ Academics Off the Record with Academics in May 2023, specifically being asked about his rivalry with Bowman in response to the interviewer's question about whether defendant Banks was triggered by the slide for Von comments. And defendant Banks responded, for some reason, I just don't see them comments no more. For some odd reason. Might be the water. We're here though. We different interact. Social media documenting the pressure that fans place on defendant Banks to slide for Von, including but not limited to comments on defendant Banks' X account at Lil Durk posted 2022 stated, "The voice in the moon pay." Comments on defendant Banks' X account Lil Durk posted on April 23rd, 2022 stating RP Von. To the extent the court determines these acts are neither direct evidence of or intertwined with the charges in the second superseding indictment, these acts are admissible to show defendant Banks' motive, intent, preparation, plan, knowledge, identity, absence of mistake, and lack of accident. Evidence related to Durk Banks directing and ordering violence against rivals. Evidence related to defendant Durk Banks' bounty for killing Stephon Mack on January 27, 2022 as charged in U.S. Montgomery Wilson, including but not limited to surveillance footage of the shooting, text messages recovered from defendant Montgomery Wilson's cell phone discussing payment from OTF and defendant in addition to the audio file that has been previously produced to you in discovery. The government will produce this podcast in video format. So they're going to use academics' damn podcast. Yeah, The government will produce screen captures of these comments in an upcoming production of Discovery. So everybody who was trolling him in the comments, y'all name is going to be brought up. Banks murder for hire. 3, a Facebook story of Montgomery Wilson's account showing him holding money while a song by defendant Banks played in the background. DNA and fingerprint analysis linking defendants Montgomery Wilson and Powell to the shooter's vehicle. So that's all the evidence. Defendant Banks and others involved in the murder of SR sought to exact revenge. Blah, blah, blah. They're just talking about this right here. Well, no, I gotta read this. Evidence that defendant Banks and others involved in the murder of SR sought to exact revenge on another rival of defendant Banks at defendant Banks' direction. Specifically, in April 2023, text messages by and between defendant Banks and OTF members, including defendant Deandre Wilson, Antonio Jones, aka Booney Mo, and PW1, showed defendant Banks feud with O-Block member Munna Duke over defendant Banks' belief that O-Block members were not properly retaliating for Bennett's death. In a thread, defendant Banks states, "I'm finna pipe it up." Never mind. To which Booney Mo responds, "Blood is green emoji of car and green light, getting shit together. Now, no phones." As set forth in cooperative discovery produced to you, the government expects PW1 to testify that in response to defendant Banks' direction to exact revenge on O-Block members, PW1 and Booney Mo purchased a vehicle with funds from defendant Banks to travel to O-Block and kill whatever O-Block members they could find. PW1 is also expected to testify that PW1 would have been expected to be paid by defendant Banks for anyone the co-conspirators killed, but that the co-conspirators did not go through with the plan because of police presence in O-Block. Evidence that defendant Banks and other OTF members involved in the murder of SR discussed violence against another rival of defendant Banks at defendant Banks' direction, specifically on April 23rd. Text message thread between defendant Banks, co-defendant Wilson, Booney Mo, and Devontae Collier, aka Zoo, wherein defendant Banks sends a screenshot of an Instagram message sent to Richard Ramsey at Richo_Lamron300 that says, "I got them hunting for you. I got them hunting you up, ads better have 3 ski masks on." On April 23rd, 2023, audio voice messages from defendant Banks' close associate Booney Mo, PW1. In a voice message, Booney Mo conveys direction from OTF leader defendant Banks, referred to by his alias Blood, about how defendant Banks wants money spent, including he wants people to get sliders and stuff like that for sure, referring to vehicles used to commit criminal activity. Defendant Banks' admissions and lyrics, paying for bounties and directed violence. Smirk slide. So I slide, don't respond to shit for Vaughn. Yeah. I'm like, fuck it, you tripping, go get your gun, let's get it. They sliding, the feds are coming. Yeah. Rumors by Gucci Mane. I don't want no niggas, I want you to catch the one I paid for. Trolling ass, we shot your homie. Schoom his ass. These acts are admissible to show Banks' motive, intent, preparation, plan, knowledge, identity, absence of mistakes, and lack of accident. We reserve the right to supplement this notice as necessary before trial. Please let us know if you have any questions or would like further discuss any of the matters raised above. Very truly yours. And this is from Ian Yanello, Gregory Staples, Daniel H. Weiner, United States Attorneys. Yeah, I ain't gonna lie, bro. They got a lot of stuff against Durk. This is more revealing of what the hell evidence they have stacked against Lil Durk. And I ain't gonna hold you. If y'all mad at Dede for this shit, you can't be. You can't. But at certain points in times, if you ain't signing no plea deal against nobody and you only stating what they state, then so be it. It's not like he's actually saying these things happen. What he's saying is that you guys allege that this crap happened, and since you guys allege that this crap happened, bruh, I'm not messing with none of this shit. Y'all gotta get me the hell up out of here. I ain't gonna hold you. It just is what it is. Man, it's bad though. If you sitting here and you a Lil Durk fan and y'all saying, man, shit, Ceddy Nash, how you gonna spend this? Easy. Where's the RICOs for everybody else? This should be a RICO of OTF. This should be way bigger than that. See, this is the thing that the government knows. We can say you did all of these things. You did this, you did that, you did this, you did that. That's like saying, hey, bro, you walked into a store with 3 people and y'all intention was to steal. That's conspiracy, if you all agreed to it. But the fact that they throwing all of these people's names in there, they're doing that to tarnish the face, to tarnish the body, to tarnish OTF and Lil Durk. Remember, if I'm going to say, yo, this cat's a mastermind, he want people dead, you think I'm only going to show just this one thing against Quando Rondo? No. We gonna talk about that shooting that actually happened at that gas station when Quando Rondo ass was sitting up there basically with some girl, and he did the show and all that shit, and nobody showed up because people were scared. Bruh, I hate to say this, but if Durk was that goddamn dumb, if Durk was that damn stupid, that's on you. We can holler free Durk all we want, but we can't free Durk of stupid shit that he did in the past. I don't care when you wisened up. That does not clear you of past atrocities. And if that does not clear you of past atrocities, you can't now then go say, Alhamdulillah, Alhamdulillah, Subhanallah, Alhamdulillah, Allahu Akbar. You can't do none of that. That don't absolve you of no sins, bro. Now, either Durk is smart enough to know and say, I knew what was about to happen. I did all this shit. I'm good with that. I live my life. I got married. My kids is good. My wife is good. She got my money. She gonna make sure everybody good. If that's Durk's whole mindset, cool. But as it stands right now, the feds still had to prove all of this shit. And the fact that y'all know that the feds is scrambling to throw shit and see if it sticks is because you seen remnants of this in the YSL trial. The similarities are insane. They're going to try to call them unindicted, co-conspirators, but we know better. Because if the trial was good enough, why the hell wouldn't they include all of this stuff? The Stefan Mack and all this shit, bro. The Illinois DA already, the state of Illinois already said, bro, Durk ain't had nothing to do with this shit. These is cats that ran around and acted like for clout that they got money for that shit. When in all actuality, they going to have to prove that. But there are things that are under seal, so we will see. But other than that, bro, it's really about them getting these damn text messages, these cops and these witnesses to say, yeah, he did it. And I don't think the witnesses that they think they have are telling them the story that they want to hear. They're still trying to work them in like, oh, tell us about this thing. You ain't got to tell us about that. Tell us about this. These are all ideas. How the hell you going to say we cop cars and sliders and all of this shit and everything, and we was going to go and kill some O-Block members, but, you know, we couldn't go do it, so we actually didn't get paid? That sound like y'all wanted to go play bully ball on these niggas because y'all getting trolled out y'all asses by these damn comments on Instagram, and y'all dumb asses thought, I'm finna go over here, go slide on these niggas and tell Durk, hey, bro, we put belt to ass on these cats, and it is what it is. But y'all, let me know your thoughts on this. I know this is a longer video, and I know y'all thoroughly enjoyed this. So if you can, hit that like button like you like something, and let me know your thoughts. That'll automatically include you in a chance to win one of these. We are 39K away from that goddamn giveaway. But click right here to keep up with the last video that some of y'all took wrong, but it is what it is. When I put the word might in there, y'all skip that word. Probably want to do that, but click right here and see how all of this shit damn near started, and hit the playlist if you don't even want to wait for the next video, and you can get caught up on everything. I'll catch y'all in the next one.